Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. The code IBC 2016 has been able to considerably improve the economic culture in our country, especially with its creditor in possession model. And with its special thrust to the MSME sector, it has further contributed towards the strengthening of our economy. To further its objectives, our courts have been consistently trying to clarify the gray areas in the code. So, friends, I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements under the code IBC 2016 and to navigate through the intricacies of its proceedings. So, let us today discuss an important case. So this is the case of Bank of Baroda versus Sri Rajasthan Syntex Limited, which was decided on the 10th of February 2025 by Honorable NCLAT, New Delhi. So let us see the factual background of the case. Messrs. Sri Rajasthan Syntex Limited, which is the corporate debtor, had been extended financial facilities by consortium of lenders, which included State Bank of India, IDBI Bank, and Bank of Baroda. And the accounts of the CD were classified as NPA in 2017. The CD gave an OTS proposal to the consortium of lenders in the year 2020 and February 2022, which was pending consideration by all the three banks. On 21st of July 2020, the CD was registered as MSME, and MSME certificate was issued by the Ministry of MSME. On 29th of March 2022, SBI, via its letter, consented to the proposed offer of OTS of Rs 30 crores. IDBI Bank also, via its letter dated 13th of April 2022, consented to the proposed offer of OTS of Rs 30 crores of the CD. Bank of Baroda, who was also the member of the consortium, however, did not communicate its acceptance and filed an application on 18th of April 2022 under Section 7 of the IBC 2016 against the CD. On 4th of May 2020, Section 7 application came to be listed. The Board of Directors of the CD resolved to file an application of PPIRP, and a declaration was made by the directors on 7th of May 2022 to initiate steps for PPIRP. An application under Section 54C of the IBC was filed by the CD on 25th of July 2022. On 19th of April 2023, the adjudicating authority passed an order admitting application filed under Section 54C by the CD. By an order of the same date, that is 19th of April 2023, Section 7 application filed by the Bank of Baroda was disposed of, relying on the admission of PPIRP. The RP in the PPIRP of the CD placed a base resolution plan before the COC, where the State Bank of India had a vote share of 47.21%, and IDBI Bank 26.7% vote share, and Bank of Baroda 26.09%. The base resolution plan was placed before the COC, which came to be approved with 73.91% vote share. The RP filed an application seeking approval of the base resolution plan, which application came to be heard and decided by the adjudicating authority via its order dated 22nd of August 2023. Now, the Bank of Baroda, which was the financial creditor of the CD, filed these appeals challenging three different orders passed by the Honorable NCLT. Appeal was filed challenging order dated 19th of April 2023, by which order Section 7 application filed by the Bank of Baroda was disposed of, noticing admission of pre-packaged insolvency resolution process against the CD, initiated by order dated 19th of April 2023. giving liberty to the Bank of Baroda to file claim before the IRP. Appeal was filed challenging order dated 19th of April 2023, by which order AA admitted application filed under section 54C by the CD for initiation of PPIRP. Appeal was filed against the order dated 22nd of August 2023, by which order AA approved the resolution plan in the PPIRP of the CD. Now, what were the questions before the Honorable NCLAT? Whether the CD, on the strength of registration dated 21st of July 2020, issued by MSME, can be treated to be an MSME. Whether the value of its plant machinery and equipment is more than rupees 50 crores as submitted by the appellant in the year 21-22. Whether the period of 14 days as referred to in section 11A subsection 3 of the IBC is directory. That is, whether an application under section 54C filed even after 14 days of filing of section 7 application, the adjudicating authority can proceed to decide section 54C application first. What is the intent and purpose of 14 days provided in section 11A3? In the event it is held that period of 14 days as mentioned in 11A3 is mandatory, what is the consequence on the order dated 19th of April 2023 passed by the AA, which has been challenged in these two appeals? Whether in the facts of the present case, when resolution plan has been approved in the PPIRP of the CD, which plan also stands implemented, the appellant has made out a case to set aside the orders dated 19th of April 23, admitting application under section 54C, and the order dated 22nd of August 23, approving the base resolution plan. Whether in the facts of the present case, the appellant has made out a case for directing section 7 application filed by the appellant on 18th of April 22 to be heard and decided on merits by setting aside all actions taken in application under section 54C. And whether the payment to the appellant, that is dissenting financial creditor, in the resolution plan is in accordance with section 30 subsection 2B of the IBC. Now let us see the findings by the Honorable Court and their decisions. Now, under section 8 of the MSME Act 2006, a notification dated 26th of June 2020 was issued by the Ministry of MSME, providing for classification of enterprises. The CD has brought on record the registration certificate, which was granted to the CD on 21st of July 2020, which indicates that the CD was classified as small enterprise type based on financial year 2021. The notification dated 26th of June 2020 in clause 4 clearly provides that the calculation of investment in plant machinery or equipment will be linked to the income tax return of the previous years filed under the Income Tax Act 1961. The CD has given the details of the ITR of the CD, based on which the classification of the MSME was changed automatically from year to year. The appellate tribunal thus does not find any error in classification of the CD as MSME. This tribunal in Ramesh Shah versus Central Bank of India and others had clearly laid down that the adjudicating authority is not expected to go into accounts and examination of certificates issued by the competent authority under MSME Act and notification issued thereunder, or modify, revise, revoke, or interfere in any manner with the MSME registration granted, etc. In view of the aforesaid discussion, the Honorable Appellate Tribunal was satisfied that the CD had valid MSME registration certificate dated 21st of July 2020, and CD as MSME was eligible to file application under section 54C. The first two questions have thus been answered. Now, whether the period of 14 days, as referred to in section 11A3 of the IBC, is directory or mandatory. Now, the submission which has been pressed by the appellant is that the application under section 7, having been filed on 18th of April 2022, and the application under section 54C, having been filed on 25th of July 2022, that is much beyond 14 days period. Application under section 7 ought to have been first disposed of, which is mandatory requirement under section 11A3, and the adjudicating authority erred in first considering section 54C application and admitted the same. Now, it is a well settled principle of statutory interpretation that when the statute itself contemplates consequence, the provision is always treated as mandatory. Subsection 3 of section 11A deals with the time period and is a clear statutory prescription that where an application under section 54C is filed after 14 days of the filing of any application under section 7, the adjudicating authority shall first dispose of the application under section 7. The mandate to first dispose of application under section 7 is clearly indicated in the provision. Now, period of 14 days referred to in section 11A3 is mandatory, and the said period of 14 days cannot be read as directory. Now, whether the period which is required for compliance of mandatory requirement under section 54A and 54B before filing an application under section 54C needs to be excluded while computing 14 days period under section 11A of IBC. Now, the legislature was well aware of the statutory scheme, and the statutory scheme does not indicate that while computing 14 days period as referred to in section 11A, any exclusion of period is provided. Filing an application under section 7, 9, 10 and 54C is a well-known concept. NCLT Rules 2016 defines the expression filed in Rule 2, Sub-Rule 14, which means filed in the office of the registry of the tribunal. Now, the Honorable Appellate Tribunal thus formed the view that an application under section 54C was filed after 14 days from the filing of section 7 application. Now, whether in view of the period of 14 days mandatory under section 11A3 of IBC, in the facts of the present case, it is needed to set aside order dated 19th of April 2023, admitting section 54C application and direct for a fresh consideration of section 7 application filed by the Bank of Baroda. Now, the facts as noticed above indicate that CD is an MSME. The IBC provide for special protection to the purpose and object of quick resolution of MSME. The object of the IBC is resolution of the CD. The present is a case which consists of 3 consortium members of the bank, SBI being 47.21%, IDBI 26.70%, and Bank of Baroda with 26.0% vote share. Both the lenders, that is SBI and IDBI, had also granted approval of negotiated settlement much prior to the filing of Section 7 application. Both the above lenders have also approved the resolution plan, and the resolution plan now stands approved with 73.91% vote share. Lenders are receiving the payouts under the plan, which is more than 30% of their outstanding dues. And Section 7 application filed by the Bank of Baroda was for resolution of the CD. And today, when the CD stands resolved and payments have been received by all financial creditors, including the Bank of Baroda, therefore, at this stage, no useful purpose shall be served in setting aside order dated 19th of April 2023, passed by AA, admitting Section 54C application and directing for fresh consideration of Section 7 application. The Honorable Tribunal, thus, in the facts of the present case, is of the view that the CD having been resolved by making payments to all the lenders, including the appellant, it is not in the interest of all the stakeholders of the CD to set aside the entire action taken under Section 54C and direct for hearing of Section 7 application filed by the Bank of Baroda, which was for the purpose of resolution of the CD. Now, whether the decision has been made in the favor of the appellant, Bank of Baroda, is not in accordance with Section 30, subsection 2 of the resolution plan approved by the adjudicating authority, and it is not in accordance with IBC. Hence, the impugned order needs to be set aside. Now, Section 30, subsection 2b, which has been inserted in the IBC, provides for the payment of debt of financial creditors who do not vote in favor of the resolution plan, which shall not be less than the amount to be paid to such creditors in accordance with Section 53, subsection 1. Section 54K3, the resolution plans and the base resolution plan has to be in compliance with Section 30, subsection 2. The Honorable Court thus directed that when resolution plan has been approved and implemented, ends of justice will be served in directing the SRA to make the payment of differential amount, if any, to the appellant as per Section 30, subsection 2b, which payments to be made within a period of 30 days from that day. The court further directed the RP to compute the said amount and intimate the SRA within 2 weeks from that day. So we conclude that all the appeals were thus disposed of, while clarifying that the adjudicating authority is not expected to go into the accounts and examination of certificates issued by the competent authority under MSME Act. It is declared that the period of 14 days, as mentioned in Section 11A3, is mandatory. And further, the statutory scheme does not indicate that while computing 14 days period as referred to in Section 11A, any exclusion of period is provided. Now, the object of the IBC is resolution of the CD. Section 7 application filed by the Bank of Baroda was for resolution of the CD. And once, when the CD stands resolved by making payments to all the lenders, including the appellant, it is not in the interest of all the stakeholders or the CD to set aside the entire action taken under Section 54C and direct for hearing of Section 7 application filed by the Bank of Baroda, which was for the purpose of the resolution of the CD. The resolution plans and the base resolution plan has to be in compliance of Section 30, subsection 2. So, friends, we see here that the courts have supported the ends of justice and have supported the cause of resolution, which is at the heart of the Code IBC 2016. Doing this, the Honorable Court has also protected the interests of an MSME. So, friends, I hope that this judgment will be of help to all my friends. And for further insights into such judicial pronouncements under the Code IBC 2016, please like and subscribe my YouTube channel. So, friends, thank you for being with me here today. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.